Hey everybody, welcome in to New World News. First story of the day is, of course, the Supreme Court has ruled against the state of New York City and their tough requirements for ownership of guns and concealed carry weapons permits. They have shot down a previous ruling that basically said people in New York that want to carry a gun and get a license and say they're doing it for protection or self-defense is not reason enough to own a weapon or a concealed carry license, which is absurd. If I want to carry it because of self-defense, that's it. That's enough. And the Supreme Court agrees, and they are now overruling that law as unconstitutional. And as a New Yorker, you will be able to, in the future, I don't know how long it's going to take to implement, but you will be able to tell the state that you want a gun for self-protection, defense reasons, and they will have to issue you a concealed carry weapons permit so that you can get a gun and protect yourself. Let's go look at the Supreme Court's ruling. 6-3, they ruled in favor of this. Of course, there are 3 people on the Supreme Court, I won't name names, who are anti-gun, but you know what? They're overruled by the majority, and that's democracy, and that's how this country works, and that's how the Constitution works. And the 3 people on the Supreme Court, in my opinion, who are ruling against this and say that this should be the law, are ruling against our constitutional rights, and I wish they would be history out of the Supreme Court, but unfortunately, they're there for life. So let's go over and take a look at their ruling. All right, here it is. The Supreme Court gun decision shoots down the New York rule that set high bar for concealed carry licenses. It's its first major gun case in more than a decade via Fox News. The Supreme Court ruled 6-3 that New York's regulations that made it difficult to obtain a license to carry a concealed handgun were unconstitutionally restrictive and that it should be easier to obtain such a license. The existing standard required an applicant to show proper cause for seeking a license and allowed New York officials to exercise discretion in determining whether a person has shown a good enough reason for needing to carry a firearm. Stating that one wished to protect themselves or their property was not enough. I mean, what other reason do you have besides hunting that you need a gun? To hunt or to protect yourself? That's reason enough, period. In this case, petitioners and respondents agree that ordinary law-abiding citizens have a similar right to carry handguns publicly for their self-defense. We too agree and now hold consistent with Heller and McDonald, and the 2nd and 14th Amendments protect an individual's right to carry a handgun for self-defense outside of the home, Justice Clarence Thomas wrote in the court's opinion, referencing 2 previous gun cases. Because the state of New York issues public carry license only when an applicant demonstrates a special need for self-defense, we conclude that the state's licensing regimen violates the Constitution. Agreed. Thomas noted that the state statute does not define what proper cause means and that the courts had ruled that the standard was met by people who showed a special need for self-protection. This special need standard is demanding. For example, living or working in an area noted for criminal activity does not suffice. In 43 other states, Thomas noted, authorities are required to issue license to applicants who meet certain requirements, and officials do not have discretion to say no due to what they believed is insufficient need. In a concurring opinion, Justice Brett Kavanaugh noted that Thursday's ruling does not prohibit states from setting requirements and that it addresses only the unusual discretionary licensing regimes. The case, New York State Rifle and Pistol Association Incorporated versus Bruin, was the first major gun rights case before the Supreme Court in more than a decade. In the majority opinion, Thomas referenced 2010's McDonald versus the City of Chicago and 2008's DC versus Heller in his reasoning for Thursday's ruling. So there it is. New York now has to issue license. If you say you want to protect yourself, you can get a license, concealed carry license in the state of New York, just like you can here in Florida. In Florida, you don't even have to give them a reason. You just walk in and say, I want to buy a gun. I want to get my license. You take your class. It's like one day. It's a couple hours. You pay your $50 and boom, you're all set. You're all on your way. You got a license. And as long as you don't have any prior criminal records, abuse or violence or any of that kind of stuff, and you're not a fugitive or anybody like that, and you don't have mental health issues that have been diagnosed on your record, you can walk into Florida and get a gun, period. That's it. You're of age. That's the 3 requirements in Florida. You have to be of age, you have to have no prior criminal activity, and you have to not have a mental health thing on your record, like a schizophrenic type thing on your record. There's some issues with that. But other than that, you walk in and get a gun and you get your concealed carry license, you're all set. I've had mine for probably going on 10 years now. So there you go. That's a really good decision. Supreme Court, way to go. Way to uphold the Constitution, and I applaud it. What do you think of it? Put it down in the comment section below. Let's hear what you guys think about New York changing their law and the country and the Supreme Court ruling on that. I'll look for the comments, respond to as many as I can. As always, thank you for watching. Hit that like button. If you have just a second to hit the like and subscribe button, I'd really appreciate it. I'd love to see you guys back. And until that next video, have a wonderful rest of your evening, and I'll see you then.